Ah, welcome to tea time. Liberty time. On today's episode, we're going to be talking about driving versus the right to travel. Now, a lot of you may be asking yourselves, Mark, what's the big deal? It's just driving. It's the law. What's the big deal? Just don't make any cops mad. Just pay your fines. Just go along to get along. Less hassle for you. What's the problem? If you get pulled over, just pay the ticket or go to traffic school. In fact, did you know that there are a lot of jobs out there that won't hire you unless you have a valid driver's license? That's why we have liberTEA time. Not everybody's in the know. Here are a few U.S. Supreme Court and other high court citations proving that no license is necessary for normal use of an automobile on common ways. The right of a citizen to travel upon the public highways and to transport his property thereon by horse-drawn carriage, wagon, or automobile is not a mere privilege which may be permitted or prohibited at will, but a common right which he has under the right to life, liberty, and the pursuit of happiness. Thompson v. Smith. The use of the automobile as a necessary adjunct to the earning of a livelihood in modern life requires us, in the interest of realism, to conclude that the right to use an automobile on public highways partakes of the nature of liberty within the meaning of the constitutional guarantees. The right to operate a motor vehicle, an automobile, upon the public streets and highways is not a mere privilege. It is a right of liberty, the enjoyment of which is protected by the guarantees of the federal and state constitutions. The right to make use of an automobile as a vehicle of travel along the highways of the state is no longer an open question. The owners thereof have the same rights in the roads and streets as the drivers of horses or those riding a bicycle or traveling in some other vehicle. U.S. Supreme Court says no license is necessary to drive an automobile on public highways or streets. No license is necessary. A highway is a public way open and free to anyone who has occasion to pass along it on foot or with any kind of vehicle. There can be no question of the right of automobile owners to occupy and use the public streets of cities or highways or in the rural districts. A citizen has the right to travel upon the public highways and to transport his property thereon. The use of the highways for the purpose of travel and transportation is not a mere privilege, but a common and fundamental right of which the public and the individual cannot be rightfully deprived. The right of the citizen to travel upon the highway and to transport his property thereon, in the ordinary course of life and business, is the usual and ordinary right of the citizen, a right common to all. Every citizen has an unalienable right to make use of the public highways of the state. Every citizen has full freedom to travel from place to place in the enjoyment of life and liberty. No state government entity has the power to allow or deny passage on the highways, byways, nor waterways, transporting his vehicles and personal property for either recreation or business, but by being subject only to local regulation, i.e. safety, caution, traffic lights. Travel is not a privilege requiring licensing, vehicle registration, or forced insurances. Traffic infractions are not a crime. Persons faced with an unconstitutional licensing law which purports to require a license as a prerequisite to exercise of right may ignore the law and engage with impunity in exercise of such right. The word operator shall not include any person who solely transports his own property and who transports no persons or property for hire or compensation. Highways are for the use of the traveling public, and all have the right to use them in a reasonable and proper manner. The use thereof is an inalienable right of every citizen. A right, a constitutional right, means a right protected by the law, by the Constitution, but government does not create the idea of a right, or original rights. It acknowledges them. Those who have the right to do something cannot be licensed for what they already have the right to do, as such license would be meaningless. A license means leave to do a thing which the licensor could prevent. The object of a license is to confer a right or power which does not exist without it. The court makes it clear that a license relates to qualifications to engage in profession, business, trade, or calling. Thus, when merely traveling without compensation or profit outside of business, enterprise, or adventure with the corporate state, no license is required of the natural individual traveling for personal business, pleasure, or transportation. If state officials construe a vague statute unconstitutionally, the citizen may take them at their word and act on the assumption that the statute is void. With regard particularly to the U.S. Constitution, it is elementary that a right secured or protected by that document cannot be overthrown or impaired by any state police authority. The right to travel is so fundamental that it appears in the Articles of Confederation, which governed our society before the Constitution. The right to travel freely from state to state is a right broadly assertable against private interference, as well as governmental action, like the right of association. It is a virtually unconditional personal right, guaranteed by the Constitution to us all. Iron curtains have no place in a free world. Undoubtedly, the right of locomotion, the right to remove from one place to another according to inclination, is an attribute of personal liberty, and the right, ordinarily, of free transit from or through the territory of any state is a right secured by the Constitution. Therefore, if we have a constitutional right to something, it isn't proper or right or valid at all to make a requirement to have a license or need a license to exercise a right that we already have. It's insane. All laws which are repugnant to the Constitution are null and void. Marbury v. Madison. Where rights secured by the Constitution are involved, there can be no rule-making or legislation which would abrogate them. Miranda v. Arizona. An unconstitutional act is not law. It confers no rights, it imposes no duties, affords no protection, it creates no office, it is in legal contemplation as inoperative as though it had never been passed. Norton v. Shelby County. An administrative regulation, of course, is not a statute. A traveler on foot has the same right to use the public highway as an automobile or any other vehicle. When's the last time you saw somebody walking down the road, stopped, and asked for their license? Automotive vehicles are lawful means of conveyance and have equal rights upon the streets with horses and carriages. Persons may lawfully ride in automobiles as they may lawfully ride on bicycles. So, when's the last time you saw a bicyclist pulled over and asked for their license to bicycle? There you have it. Next time somebody comes at you with an argument that's straight out of the indoctrination manual, a side of the conversation that doesn't really come from their logical thinking ability, but rather something that's been fed to them since they were children. Something that at the age of 16 they were told that they must do, and scared into not only believing for themselves, but also holding other people under that same false pretense. Simply educate them on these things, and if you don't have one of these, get some. This has been liberTEA Time.